What if the biggest threat to a listed company is not competition, not declining sales, not rising costs, but a risk that nobody saw coming? What if a cyber attack shuts down operations overnight? What if a regulatory investigation suddenly impacts investor confidence? What if a supply chain collapse disrupts business across multiple countries? What if climate related events affect manufacturing facilities? What if a single overlooked risk wipes out years of shareholder value? And most importantly, who inside a listed company is responsible for identifying, monitoring, and managing these risks before they become corporate disasters? Is risk management merely a compliance formality? Or is it one of the most important corporate governance functions in modern business? Why has SEBI made the Risk Management Committee a mandatory governance mechanism for specified listed entities? Can directors be questioned if foreseeable risks are ignored? Can investors suffer because a company failed to establish a proper risk governance framework? And how does Regulation 28 seek to protect companies, shareholders, lenders, employees, and the securities market from preventable governance failures? Today, we are decoding one of the most strategic and forward looking provisions under the SEBI listing obligations and disclosure requirements. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Regulation 28 deals with the constitution and functioning of the Risk Management Committee. At first glance, the regulation may appear simple. However, beneath its brief wording lies one of the most important governance concepts in modern corporate regulation. The regulation recognizes a fundamental business reality. Every company faces risk. No company operates in a risk-free environment. Every business decision carries uncertainty. Every investment carries exposure. Every expansion plan carries assumptions. Every technology deployment introduces vulnerabilities. Every regulatory framework creates compliance obligations. Every market cycle creates opportunities and threats. The question is not whether risk exists. The question is whether risk is identified, understood, monitored, and managed effectively. This is precisely where Regulation 28 becomes important. Historically, corporate governance focused heavily on financial reporting and legal compliance. Over time, regulators realized that governance failures often arise because risks are not identified early enough. Financial statements may appear healthy, operations may appear stable, management may remain optimistic. Yet, serious risks may be accumulating beneath the surface. By the time those risks become visible, significant damage may already have occurred. Therefore, modern governance frameworks place substantial emphasis on risk oversight. SEBI incorporated this philosophy through Regulation 28. The legislative intent behind Regulation 28 is straightforward. SEBI wants boards to move from reactive governance to proactive governance. Instead of responding to crises after they occur, companies should anticipate risks before they materialize. Instead of merely recording losses, companies should attempt to prevent them. Instead of reacting to governance failures, companies should establish systems capable of identifying warning signals early. This is the foundation of enterprise risk management. The Risk Management Committee serves as a specialized governance body responsible for overseeing risk management practices within the organization. The committee helps ensure that risks are identified systematically, risks are evaluated objectively, risks are prioritized appropriately, risks are monitored continuously, risk mitigation measures are implemented effectively, and the board receives meaningful information regarding emerging threats. One common misconception is that risk management only concerns financial risks. In reality, risk management covers a much wider spectrum: strategic risks, operational risks, legal risks, regulatory risks, cybersecurity risks, data privacy risks, technology risks, environmental risks, climate risks, supply chain risks, reputational risks, litigation risks, human resource risks, business continuity risks, market risks, credit risks, Foreign exchange risks. Geopolitical risks. The scope is extensive. Modern companies operate within an interconnected risk environment. A single event can trigger multiple consequences. Consider a practical example. A cyber attack initially appears to be a technology issue. However, it may also create operational disruptions. It may result in legal liability. It may trigger regulatory scrutiny. It may affect customer trust. It may reduce shareholder confidence. It may impact revenue. What began as a technology risk ultimately becomes a governance risk. This interconnected nature of risk explains why Regulation 28 is so important. The Risk Management Committee functions as an institutional mechanism for evaluating such exposures. The committee is expected to assist the board in understanding risk trends and emerging vulnerabilities. It provides structured oversight. It encourages risk awareness. It supports informed decision making. And it strengthens organizational resilience. From a company secretary's perspective, Regulation 28 is not merely about constituting a committee. Effective compliance requires much more. The committee must function meaningfully. Meetings must be conducted appropriately. Risk registers must be reviewed. Management presentations must be evaluated. Emerging risks must be discussed. Minutes must accurately capture deliberations. Recommendations must be documented. Action items must be monitored. Governance effectiveness depends upon substance rather than form. Another important governance principle behind Regulation 28 is accountability. Risk management cannot remain solely within operational departments. The board must maintain oversight. Directors must understand major risks affecting the organization. Investors expect boards to exercise informed judgment. Regulators expect governance structures to function effectively. Accordingly, the Risk Management Committee serves as an important link between management and the board. A practical challenge frequently observed in companies is the tendency to focus only on historical information. Past performance is reviewed extensively. Past compliance is examined carefully. Past financial results receive detailed attention. However, governance also requires looking forward. What risks may emerge tomorrow? What vulnerabilities exist today? What developments could impact business continuity? What assumptions require reassessment? The Risk Management Committee encourages this forward-looking approach. This is one of the most valuable contributions of Regulation 28. The regulation also interacts with several provisions of the Companies Act 2013. Directors' duties under Section 166, board responsibilities under Section 134, internal financial controls, business responsibility frameworks, corporate governance disclosures. Various provisions collectively support the broader objective of risk-aware governance. Regulation 28 should therefore be viewed as part of a larger governance ecosystem. From a secretarial audit perspective, professionals should examine committee constitution, terms of reference, meeting records, risk management policies, risk assessment frameworks, and evidence of active oversight. Documentation is essential. A committee that exists only on paper offers little governance value. Auditors and regulators increasingly focus on actual effectiveness rather than formal existence. Another important aspect concerns investor confidence. Institutional investors frequently evaluate risk governance practices before making investment decisions. Sophisticated investors understand that risk management quality often influences long-term sustainability. Strong risk governance can enhance market credibility. Weak risk governance may increase investor concerns. Consequently, Regulation 28 contributes not only to compliance but also to corporate reputation and market trust. Consider another practical illustration. A manufacturing company relies heavily on a single supplier located in one geographic region. Operations appear stable. Financial performance appears strong. However, the concentration risk remains significant. A natural disaster, geopolitical event, or transportation disruption could affect business continuity. A well-functioning risk management committee would identify such exposure and recommend mitigation measures before a crisis occurs. This demonstrates the practical value of proactive risk oversight. For advocates, chartered accountants, cost accountants, and company secretaries, Regulation 28 plays an important role during governance reviews, due diligence exercises, mergers and acquisitions, ESG assessments, compliance audits, and strategic advisory engagements. Understanding risk governance has become essential in modern professional practice. The consequences of inadequate risk management can be severe: operational disruptions, financial losses, regulatory investigations, litigation exposure, reputational damage, investor dissatisfaction, market value erosion. Many major corporate failures have demonstrated that unmanaged risks eventually become governance failures. This is precisely what Regulation 28 seeks to prevent. The true spirit of Regulation 28 is not fear, it is preparedness, it is resilience, it is foresight, it is disciplined governance, it is informed decision making. It is creating an organizational culture where risks are identified early, discussed openly, and managed responsibly. Ultimately, Regulation 28 reminds us that successful corporate governance is not merely about reporting what has already happened. It is about preparing for what may happen next. And in today's rapidly changing business environment, where risks emerge faster than ever before, the Risk Management Committee has become one of the most important governance institutions, protecting companies, directors, investors, and stakeholders alike. That is why Regulation 28 remains a cornerstone of modern corporate governance and an essential provision for every compliance professional, director, investor, and governance practitioner to understand thoroughly. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.